Dr. S. G. V. Subramaniam is currently working as professor in the Environmental Studies Department of Anna University, Chennai. He has done 8 master's degrees including MBA, 6 postgraduate diplomas, a degree in law and Doctor of Philosophy in the field of environmental management and environmental law. He has done his postdoctoral work in France under the Indo-French Cultural Exchange Fellowship and at Germany under the DAAD Fellowship. He has been awarded UN Fellowship and done Diploma in International Lawmaking and Diplomacy from the University of Joensuu, Finland. He is involved in several environmental impact assessment related consultancy works. He has guided several students for their master's degree program project works. To his credit, nearly 77 papers have been published and presented in various national and international conferences. He has been nominated by His Excellency Governor of Tamil Nadu as Senate member for 2 terms to the Tamil Nadu Dr. Ambedkar Law University. He has been nominated as expert member for the State Environmental Appraisal Committee for 2 terms by the Government of India. He has served as member board of studies in the Legal Studies Department of University of Madras. Right now, he has been nominated as member board of studies in the field of environmental studies in the Thiruvalluvar University. He has written several chapters in the leading books in the field of environmental law.
Welcome to the viewers for the UGC program in the series of Environmental Science. Today I am going to give you a talk on the environmental legislations in India. For the purpose of effective environmental management, we need 3 E's. The first one is the engineering E. The second E is the education E. The third E is the enforcement E. It is needless to say that unless otherwise there is a good amount of engineering principles integrated with the technology, we cannot have a good environmental management. Take for example, for the purpose of solid waste management or the industrial waste management or the hazardous waste management, we need good amount of the engineering and the technological things for that. The second E is the education E. Unless otherwise our people are sensitized, our people have been educated what is to be done and what not to be done in order to preserve and protect our environmental things, we cannot have a good environmental management for that matter. So for that, the second E, namely the education E, is very, very essential. For this purpose only, the Supreme Court, taking that importance of environmental education in imparting to the students. In fact, this UGC program is also being conducted for the purpose of imparting the knowledge to the students and sensitize the students for that. In fact, the Supreme Court has gone one step ahead, making the environmental science and engineering as one of the compulsory subjects in the curriculum of all the undergraduate students studying the BE program or the BA program or the BSc program for that matter. The third E, which is most important, is the enforcement E. Enforcement, for the purpose of effective enforcement, we need good amount of legislations. Then for the purpose of enacting the good legislations, we need a good constitution for that matter. And again, for the purpose of enforcing these legislations, you need a good amount of executive body for that. Now, whether we are having it in India, all the 3 things means, yes, we are having. Now, I am going to go in detail about the Indian Constitution, Indian environmental laws, and how far these environmental laws are protecting our environment, and how far the executive bodies, namely the statutory bodies which are created under the statutes, namely the Central Pollution Control Board and the State Pollution Control Board, discharges its function for the purpose of effective environmental management. The contents which I am going to deliver in my lecture are importance of environmental laws, salient features of the Indian Constitution and Indian environmental legislations. Now, what are the various causes for the environmental pollution? The first one, thoughtless industrialization. The second one is the urbanization. The third one is the deforestation. And the fourth one, globalization. Now you can ask the question, how far the globalization is contributing that the environmental pollution for that. That I will be dealing it in detail in my course of lecture. The fourth one, of course, the population, poverty and shift from the traditional culture to the consumerist culture. This is very much evident. Some 20 years back, people when they are going to the school, they will be using the bag, only the cotton bag. Now it has become the fashion to use only the plastic bags. And I need not say how far the plastic has caused a good amount of environmental pollution, and plastic is being a non-biodegradable one which will be existing for decades and centuries in the atmosphere, and thereby it will be causing enormous amount of the environmental damage for that matter. Now, what are the various factors which are leading to our environmental crisis? First one, the change in the lifestyle. The second one, over exploitation of the finite resources. We know that resources are finite. If you exploit it over means automatically it will be causing a good amount of damage to the environment. Third one, population, lack of information. This lack of information, for that people are doing that environmental pollution by virtue of their ignorance. For that purpose only we have to sensitize, we have to educate, we have to give good amount of information to the people what is to be done and what not to be carried out. Then the fifth one is the mismanagement and maladministration. The sixth one, overload on the ecosystem. Every system has got certain amount of load only it can able to bear. If it is being overloaded means it will be affecting the entire ecosystem for that matter. Then the next one, is there the crisis for the purpose of effective environmental management, whether we are having the crisis in that one. Then the law crisis or the environmental law crisis or the environmental law or the environmental law. I am going to tell about what is the difference between the environmental law or the environmental law. The environmental law in the sense the legislations which are exclusively enacted for the purpose of environmental management, and the environmental laws are which are indirectly carrying out that protecting the environment and preventing the environmental pollution. Now, why we need a good amount of environmental legislations? Number one, whenever there is a law means when there is a law, then only we will get the order for that. For that purpose only we can able to see in any of the government law and order. The DIG of police, law and order. When there is a law, then there will be a law order for that. Now, systematic and orderly maintenance of that ecosystem, systematic and orderly maintenance for the effective environmental management, we need the first one, that need for the environmental law. The second one, upholding the social justice. What is after all the social justice? That is apportioning the natural resources. When the resources are being apportioned in a particular way, there it will not be affecting the social justice. That is apportioning it in such a way that each for all and all for the each means, then only we can able to uphold the social justice. The third one, proper sharing of the resources. Fourth one, balance between the environment and development. This is the most important for that matter. Why I am saying that? Because we need the development, we need the environment, then that the development should not be at the cost of environment, and environment should not be protected at the cost of development. This is a very delicate one. That is, we need the cake and we have to eat the cake also. For that purpose only, in the 1992 Rio conference, a new term has been created, namely the sustainable development. Sustainable development, we need the development, but the development must also protect the environment, and the development must be within the carrying capacity of the environment and within the regeneration capacity of the environment for that matter. This is what called the balancing the development and environment, namely the sustainable development. The next one, establish the prescriptions and prohibitions. Whenever there is a law means always it must associated with the penal actions. If there will be a commissions of the act, there will be the omissions of the act. If there is an over commission, that also to be prohibited and that also be to be penalized. Similarly, the non-doing of certain activities also, that is omissions. Omissions also must lead for some sort of, it must be prohibited, as well as if it is carried out means it has to be punished. So the law must go along with the prescriptions and prohibitions for that matter. Establish the incentives and disincentives. What is the disincentives? So there is a system. This system could be able to do, this is that amount, means if you are doing it over and above for the purpose of protecting that environment, you must be given a good suitable incentives in order to encourage you for that matter. In that case only, you have to integrate the economic aspects along with the environmental legislations that I will be dealing it in the course of my lecture. And law must not, the seventh one, not only as a litigation tool but as a management tool. This is the most unfortunate thing which is happening in our Indian scenario. Most of the time our environmental laws are used as a litigation tool rather than the management tool. The next one, the goals of the environmental law. Articulate the environmental policies and program. What is after all that environmental policy? It is nothing but the vision. What is the vision? Where we have to go? That one we are setting up, that is called the vision. And how to go? That is the mission. So, a vision without a mission without a vision is a rudderless one. And a mission without the vision is a daydreaming for that matter. So, we need a vision and we need a mission for that. And the mission is nothing but the environmental laws and the vision is nothing but the environmental policies. And for that we need a good amount of environmental policy that must articulate with a sufficient amount of the program, and those programs must be carried out along with the environmental laws or within the boundaries and within the ambit and scope of the environmental law for that matter. Then preserve, protect and conserve the natural environment. Now, I would like to say the difference between the conservation and the preservation. Conservation is something that you have to keep it as it is in the nature, that is called conservation. The conserving the forest area, conserving the wild animals. Whereas the preserving is something which is a dead one, you are protecting it, you are preserving it. This is called as a preservation. Then as coming for the protection, protection is mainly for the natural monuments for that, because that is also giving the good amount of tracing our history for that matter. Then of the people and from the people. Our environmental laws must be go along with the people. It should not separate the people from the environment for that matter. Provide institutional mechanism for the allocation of the natural resources and their use and the development process. This is what which is being enlightened for the sustainable development and upholding the social justice. When it is disproportionately shared, means the rich will become the richer and the poor will become the poorer. When it is going in this way, means our constitution, what it said in the preamble, justice, social, economic, politics. The first justice is the social justice. The social justice itself is totally defeated for that. In order to uphold the social justice, it is absolutely essential all our natural resources have to be shared equally, or the principle of equity and equality has to be maintained, which is very basically enshrined in our organic document, namely our Indian Constitution for that matter. The next one must set up the environmental standard. Must set up environmental standards in the sense, unless otherwise you set up what is to be achieved. What is the minimum standard which we require? We cannot achieve for that matter. So, setting up the goal, and we are making all the efforts to achieve that standard. For that we need the good legislations. Then, when I talk about that environmental laws, without talking about the Indian Constitution, means it is totally a soulless one for that. Now, talking about or giving a brief introduction about the Indian Constitution is one of the absolute requirement if I wanted to talk about the environmental laws for that. In that case, I would like to enshrine, I would like to give certain basic features of the Indian Constitution. As a citizen of India, it is eminently and absolutely essential for everyone to know about our Indian Constitution. So, in that case, I will just tell you briefly with say 6 or 7 slides about the Indian Constitution. Now, what is after all the Constitution? The Constitution is nothing but the organic document, defines the power and functions of the various organs of the state and their relationship. What are the various organs of the state? Namely, the first one is the legislative, the second one is the executive, third one is the judiciary, and of course, the fourth one is the press. This I can say, these four organs are the columns and pillars of the democracy. When the democracy wanted to sustain means, unless otherwise these four columns and pillars are there, the democracy cannot sustain it. One is the law, the legislation is the law making authority, the executive is the law implementing authority, the judiciary is the law interpreting authority, and whatever that is being transpired in the government, the people have to know. For that we need a free and fair press for that, and all these things are very much enshrined in our Indian Constitution. The second one, Indian Constitution is a very lengthiest constitution. The third one, it is a written constitution. Take for example, even in the developed country UK, it is not a written constitution. It is based upon the convention only, whereas Indian Constitution is a very written constitution. It consists of 443 articles divided into 26 parts and 12 schedules. It provides a parliamentary democracy with an executive responsibility to the legislature, and armed the judiciary to test the validity of the legislations. This is the most important. This is armed the judiciary to test the validity of the legislations. Suppose that legislation, if it makes any laws which is affecting the fundamental, which is infringing the fundamental rights of the Indian citizens, then Indian citizens have been given a one more right under the Article 32 of the Constitution to approach the highest judiciary, either the Honorable High Court or the Honorable Supreme Court, to get back its fundamental rights for that. This is the most important. Or otherwise, I can say the judiciary is supposed to be the testing laboratory to test the validity of the legislations, whether it is falling within the ambit and scope of the Constitution for that matter. The next one, we have got the preamble of the Constitution, next the fundamental rights in the Constitution, the third one is the directive principles, and the fourth one is the various schedules. Fundamental rights, this has been derived from the American model of the American model. The next one, parliamentary system of the government, it is drawn from the United Kingdom. Then directive principles of the state policy, it is derived from the Constitution of the Ireland. The fourth one, emergency powers, it is drawn from the German Constitution and Government of India Act 1935. Then the synthesis between the concept of individual freedom and the social justice. This is the most important for that. Individual's freedom is very much recognized, but those freedoms are within the scope of the social justice. The next one, goals of the Indian Constitution is the welfare idealism. Preamble, I have already told you the preamble. The next one, justice, social, economic, political. Then the liberty of thought, belief, worship. Then the equality of the status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Directive principles of the state policy. Now, I have given a good amount of introduction about our Constitution. Now, with reference to the environmental laws, with reference to our protection and preserving the natural environment, whether these things have been articulated in our Constitution, or whether our Constitution is a green. This is what the question mark which I am going to answer it. Yes, the first one, in the year 1976, that 42nd Amendment have been inserted in our Indian Constitution. Through the 42nd Amendments, two articles have been inserted in our Constitution, that is Article 48A and Article 51EG. What is that 48A? It says it is the fundamental duty of the state. The first one, it imposes a duty on the part of the state to protect our environment, natural resources, water streams, coastal areas, forest areas and all. So, it imposes a duty on the part of the state. State is nothing but the government. The next one, you can impart the duty for the state, but what about the citizens? They have given the duty, fundamental duty for the citizens to protect the natural environment. And here we have to appreciate, in the British period, we have been treated only as the subjects. Now we have given the status of the citizens. It is the fundamental duty of the citizens for that matter. Then after that, 11th schedule of the Constitution, a new schedule was added under the Article 243 of the Constitution in the year 1992. In that, if you see the entry number and the subject areas which are relevant to that environment, the first one, the entry number 2 with reference to land improvement, implementation of the land reforms, land consolidation and soil conservation. All these things are for the indirect, directly or indirectly with reference to the environmental protection or the environmental management for that. The next one, entry number 3, minor irrigation, water management, watershed development. I need not say the importance of that water. It is the major thing in the environment. Then the entry number 6, social forestry and the farm forestry. Then the next one, entry number 11, with the reference to the drinking water. Entry number 12, fuel and fodder. Entry number 15, non-conventional energy sources. Entry number 29, maintenance of the community assets. Assign the functions to the panchayat with a view to have an effective environmental management at the local level. Because here the panchayats have been given most important in protecting the environment. This is what exactly our vision of our father Mahatma Gandhi, that panchayat have to be given the more powers. Now this is under the 72 constitutional amendment, this has been given for that matter. Then the 12th schedule of the constitution under the article 243W wide 74th constitutional amendment, entry 8 provides urban forestry, protection of the environment, promotion of ecological aspects. It commands urban local bodies, municipalities to perform the functions of the protection of environment. Then the 7th schedule of the constitution, entry 7A, concurrent list, forest introduced. 17B, protection of the wild animals and birds have been introduced. Then the 20A, providing population control and family planning. All these things are directly or indirectly with reference to the environment. Article 253 of the constitutional obligation for the international agreements. This is, I just wanted to say a few words about that. Whenever India is entering in any of the declarations, protocols or covenants or conventions, India is giving an assurance to the international body that we will be either enacting a new legislation, or in the absence of new legislations, we will be modified the existing legislations in consonance with what that agreement we have given it to the international bodies, international community for that. So, under the article 253 of the constitutional obligations for that environmental international agreements, I can quote it here. Now, Water Prevention and Control of Pollution Act 1974 have been enacted. In the year 1972, there was a landmark in the annals of the environment, namely the Stockholm Declaration have taken place. I need not say, in that Stockholm Declaration, our Honorable then Prime Minister of India, Srimati Indira Gandhi, was addressing the keynote address she was giving it. Then, after the Stockholm Declaration, we have given an assurance to the international body, international community, that we will be proceeding with our environmental things as per the Stockholm Declaration, and from that, by using that article 253 of the Constitution, we have enacted a new legislations for the purpose, exclusively for the purpose of protecting our water bodies or the water. That is Water Prevention and Control of Pollution Act 1974. Then, similarly, in the year 1981, we have enacted an exclusive legislation for the purpose of protecting our air. That is the Air Prevention and Control of Pollution Act 1981. Then, in the year 1986, an Umbrella Act, we were having it for the purpose of protecting our water bodies, namely the Water Act, and for the Air Act, but environment does not restrict only with reference to the water and air. It is anything and everything can be brought under the umbrella of environment. Realizing this one, in the year 1986, Government of India, our Indian Parliament has enacted an Umbrella Act, namely the Environmental Protection Act. All these acts in the preamble, if you see it, they are enacted to implement the decisions reached at the United Nations Conference on the Human Environment 1972, that is nothing but the Stockholm Declaration. Right. Part 9 of the inserted 74th Constitutional Amendment in the year 1972, that is namely the Panchayat Raj. Panchayat Raj is nothing but the devolution of the powers. Devolution of the powers to the municipalities. And environmental status report, based upon this one only, every municipality, every Panchayat have to submit a report on the June 1st to the respective government about the environmental status of that area for that. The next one, 42nd Constitutional Amendment, I have already told you, and 48A also I have already told you. Once again, I just wanted to read that the state shall endeavour to protect and improve the environment, safeguard the forest and wildlife of the country. Then, obligations on the part of the citizens, that is being enshrined in the Article 51AG. In that, it imposes, already I have explained to you, now I am reading it word by word. It imposes a fundamental duty to every citizen of India to protect, improve the natural environment, including the forest, lakes, rivers, wildlife, and to have a compassion for the living creatures. This is the most important. It is not only the protecting and preserving it, you should have a compassion. Compassion is nothing but you should have an emotional bonding with the living creatures. Thereby, it is indirectly stressing the need of value of the human being or the value of the humanism for that matter. The next one, the dual duty which is imposed on every citizen, not only to protect environment for any kind of pollution, but also improving. This is the most important. You cannot just simply keep it and viewing it. You have to keep it simultaneously, you have to improve it. That is the most important. This has been enlightened. Then, Article 47 of the Indian Constitution, it makes a reference to the improvement of the public health as one of the primary duties of the state. In fact, it envisages a pollution-free environment for all the people. 47, I will read it word by word. The state shall regard the raising of the level of the nutrition standard and the standard of living of its people and the improvement of the public health among the primary duties, and in particular, the state shall endeavour to bring about the prohibition of the consumption of alcohol except for the medical purposes, consumption of alcohol, intoxicating drinks, drugs which are injurious to the health. Then 49 and the environment. 49 imposes an obligation on the state to protect every monument or place of object, articles, historic interest to be the national importance and from the spoliation, disfigurement, destruction, removal, disposal or export as the case may be. Then it shall be the obligation on the state. The state has got an obligation to protect the national monument. Then the next one. The policy adopts the 4 guiding principles. First one, prevention of pollution at the source. The second one, adoption of the best available technology. The third one, polluter pays principle. The fourth one, public participation. So, every country faces problems. That problem is, first letter is the P. 3 things which is leading to this problem. Number 1, poverty. Number 2, population. Number 3, pollution. Pollution in the sense environmental pollution. Now, if you wanted to minimize the environmental pollution, if you wanted to have an effective environmental management, again the 3 P's are essential. The first P, namely the political will. Whenever we wanted to have effectively implement any project, unless otherwise there is a political will, it cannot be done. The second P, namely the public participation. If there is no participation from the public, even though there is a political will, if there is a good amount of opposition from the public, then that project cannot be implemented. The third P, which is very, very, very essential, I can say, is namely the professional ethics. Professional ethics is something which we have to answer to our conscience, that we have to answer, we have to proceed it as per the ethical principles which are laid down by our ancestors. If these ethical principles are followed, then automatically that professional ethics is being maintained, automatically we can have a good amount of environmental management for that. Now, the policy of our environmental policy and the guiding principles, namely the prevention of the pollution at the source. Why I am saying is, environmental pollution, we were having it only the end pipe treatment. The days have gone. We don't want any end pipe treatment. We wanted to reduce the pollution at the source itself. The second one, best available technology. Best available technology, the technology is continuously developing. Whatever the technology which is a best one at the time of implementing it, we have to adopt that technology for that so that we can minimize with the pollution. I am saying it here, we cannot avoid the pollution. It is totally impossible to avoid the pollution, whereas we can minimize the pollution by integrating the various pollution control mechanisms not only at the end pipe treatment but also doing it at the process control or the process itself and by following the best available technology. The third one, the polluter pays principle. This principle has emerged in the recent days by the virtue of our Supreme Court judgment. What is that polluter pays principle? One who is polluting have to pay for the pollution. Now, just because I have been given the right that since I am paying it, I have not been given the right to pollute for that. So, you should not read it on the other way. Whatever the pollution or whatever the damage which have been caused but not following the best available technology in the past, now in order to retrieve back the ecosystem to original condition, whatever that polluter, whatever that person who was polluted, he has to pay for that in order to get back that original environment. This is what called as the polluter pays principle. Based upon the polluter pays principle, several legislations have also been brought or several authorities have also been brought. One such authority was the Laws of Ecology Authority, which was functioning in the Tamil Nadu. Then the second one such is that legislation, that is, for example, the old car, they have to pay more amount of the tax because the old cars are polluting more than the recent cars by following the polluter pays principle. Then the public participation in the decision making. Unless otherwise the public cooperation, unless otherwise the public is participated, you cannot effectively not only enforce our legislation but also you cannot have a good management for that. Now, I would like to put it in the form of a summary. The first one, environmental law and their objectives. And in the second, Indian Constitution, because my lecture is restricted to our Indian setup, I have given about the introduction about our Indian Constitution. The third one, which we are going to deal, the various Indian environmental legislations and how far these legislations are protecting our environment. Now, I am going to put the questions to you. First one, what is the necessity of the environmental legislations? Number two, what are the salient features of the Indian Constitution? The third one, what are the articles in the Indian Constitution with reference to environmental protection? So, my dear students, with this thing, I am concluding the first part with reference to the environmental legislations. The second part, we will have it in the next session. So, once again, I am thank you.